So there's a number of steps that trademark owners can take to enforce their rights now that they've sort of done the policing part and they've identified potential issues. One is if you're dealing with a situation where a third party in the marketplace, and by marketplace I just mean out there somewhere in use, product being sold, services being offered, someone's using an infringing mark, you want to assess whether it's a problem, and assuming you've sort of vetted it with your legal counsel or otherwise and determined that it is objectionable, send a cease and desist letter. And there's a lot of different flavors of that. You can send sort of a softly worded cautionary letter, something that's a little bit more of a warning. If you continue to do activities X, Y, and Z, we will object. As long as you stay in this little area, we won't object. Or you can outright object to the whole thing and demand that they stop all use of that particular mark for the particular goods or services. And that's one way to tackle that problem. Another mechanism relating to what I mentioned earlier about the trademark register is utilizing the Patent and Trademark Office's opposition procedure. So if someone were to file a trademark application for a mark that you deem too close to your own, you can oppose that trademark application once it gets to a certain point in the process. And the opposition before the Trademark Office is sort of like a mini litigation process. It's not quite as expensive and involved as a full-blown litigation before the courts, but it uses a lot of the same procedures as court litigation. So it's something to sort of employ along with other methods such as sending a demand letter and such. And then of course there's sort of the final and most comprehensive step, which would be to file a federal lawsuit and actually sue the party that is infringing your mark, whether it's over a use issue in the marketplace, a registration issue before the Trademark Office, or oftentimes it's both. The thing about bringing an action in court is you can get an injunction to order the party to stop using the infringing mark. You can potentially get damages for use that has already occurred, and there's a variety of other remedies as well. So it's a more comprehensive option. It's also a more expensive route to go.